Welcome to the Sam the Answer Man podcast. For 30 years, Sam Ventola has been an attorney, hearing officer, professor, and mediator. Now he's here to answer your legal questions. Sam the Answer Man, Law Made Simple. Here's your hosts, Sam and Gina Ventola.
Hey, podcast fans. Welcome to the Sam the Answer Man podcast. I'm Gina.
And I'm Sam.
And we're so glad that you're listening. So, Sam, I want to talk about employment agreements, specifically employment at will agreements.
Right.
Could you elaborate on that? First, tell us what they are, what their purpose is, and then kind of elaborate on them.
So a lot of people think that with their employees, other than high-level employees who might have an employment agreement, they don't want an agreement with their employees. They don't want it to be a no-contract situation because they think that helps them prevent claims. And that's, only really half true. A better situation, rather than having no contract at all, is having a contract which specifies, yes, the parties agree that we have an employment at will. So employment is generally considered to be at will. And what that means is that either party can, without liability, end the employment arrangement, as long as they're not acting according to some reason that's specifically prohibited in the law. So employers look at this as an important thing, that they can fire their employees when they want to and not have to justify it. So a lot of people say, well, to maintain the employment at will situation, I want to make sure I do not have a contract with this employee. And I actually counsel against that. I actually think you want a contract that specifically says, yes, the employment is at will. And it can specify that and a number of other things that will help clarify the employment situation going forward that I think will really minimize the risk that you end up in litigation with this employee down the road.
So can you give us some examples of those?
So the first one is a very open and clear statement that the employment is at will, meaning that it can be terminated by either party for any reason or for no reason, and that there's no liability for that. A second thing that I think is often important in employment contracts is a clear explanation as to how compensation is to be calculated. A lot of times I've seen litigation come up where it was they were looking back at something in an employment manual or some kind of document that's meant to explain a commission program or a bonus program, and a lot of times the language in these things is not clear. And so I think if it's something you confront when you're creating a standard form employment at will agreement or a specific employment at will agreement with a employee who has a unique compensation system, that you can make sure that these things are drafted so that they're not going to create those problems down the road. And this is one of the examples, I think we talked about this before, that I think for your transactional stuff, you may find an advantage in having an attorney who is experienced in the litigation side, because I have seen so many cases blow up over language that the employer probably thought was clear when they wrote it, but there are ambiguities in it and created an issue that had that result in expensive litigation down the road. If you take on an attorney who has an eye for those things and can draft a compensation plan or a system that's specific, then you minimize the chance that you have those problems down the road. Another thing that's important, and again, this is in order to avoid problems down the road, is issues of sexual or other harassment. Now, again, people normally have manuals that say, sexual harassment is prohibited, we don't do that, and report it. But a lot of times it's not clear in those documents how exactly something is supposed to be reported, particularly if the person who's accused of the sexual harassment is the supervisor of the person who's making the complaint. So a lot of times people will bring these things and say, hey, I never really knew, what I was supposed to do. If you have these procedures in an employment at will agreement that the employee is actually signed, then you can show, hey, we had specified right there, that if you can either go to this person or this person, there were multiple ways that you can make the allegation, and that it would be investigated, and that it's not tolerated. That'll help you down the road if you're ever a claim of sexual harassment by this employee, and it would help you better than if you just had that in the manuals.
So what can business owners do in these situations like this, their business is growing, they're starting to hire employees, what should they do?
Well, that depends on the kind of business. Like, for example, if you're in a business that involves a lot of creation of new ideas or new products, you know, you may be in a situation where an employee comes up with something, and when they leave, they say, well, this is mine, and I'm going to keep it. You know, normally people think that the law involves a lot of requirements of having magic words, and normally that's not true. Normally regular language is appropriate. However, this is one place where magic words are required. If you are going to try to make sure that the employee's inventions are those of the employer, not of the employee, you have to do what's called a work for hire clause. And again, I think that's also an appropriate thing for an employment and will agreement, is to have it in there. Again, you have your employee's specific signature on that document. So that's really good. Another thing that comes up, and it depends on the business again, is, you know, whether you require confidentiality, whether you want the employee to sign on to a specific confidentiality promise, if you have specific conflict of interest language that you want to make sure that you don't have an issue with, again, depending on your part of business, or if you want to assert a restrictive covenant. And we're going to be doing another podcast on restrictive covenants. I mean, covenants not to compete. So, but if those are things that you want to try to bind the employee to, covenant not to compete, confidentiality, conflict of interest policy, again, I think those are appropriate things that you want to try to put in an employment and will agreement.
There you have it. Sam, that was pretty helpful information.
You know, another thing that I've seen, you know, blow up, and again, might be appropriate to put in a employment and will agreement, is vacation policy. A lot of times an employee will work year after year after year, and the vacation policy won't be clear. And it won't be clear, for example, that vacation is lost at the end of the year. And a lot of times people, again, think that they've written these policies, that they make sense, but it turns out that they don't. So that's an example of something to put in an employment and will agreement. Another thing that I ask employers to consider is a jury trial waiver. A lot of times employers think that they're supposed to have an arbitration clause. And there are a lot of downsides for that. We've talked about that in a lot of other podcasts. But if you don't want an arbitration clause, which you probably don't, a better alternative might be a jury trial waiver, which probably is going to be enforceable. And it says that if you have any litigation with the employee, it's going to be tried before a judge and not a jury. And that eliminates a lot of the leverage that plaintiff's lawyers have. They'll say, hey, you're going to have to go before a jury, and juries tend to sympathize with the employee. You won't have that problem if you've got a jury trial waiver. And finally, you know, as with employment manual, you want an acknowledgement that the employee's read that document and that it takes precedence over any other document that may exist. There's also a way to put in the document a limitation of authority. So an employee might say that, hey, after I signed this, my boss or some other person with authority came in and said, oh, despite what we said there, your employment's not at will, we won't fire you. And you don't have any way of arguing against that, because the employee might say this person looked like they had authority. The limitation on authority in the employment and will agreement is going to be something that's going to be binding on the employee. They will be given notice of a limitation on authority. So again, I think that's an appropriate thing to do, to limit authority, to make changes to that document to something like the board of directors or something where the employee won't be able to say, you know, oh yeah, that happened.
Wow, that is a lot of information.
Yeah, and it's not, you know, it's going to depend upon the employer, it's going to depend on the employee, and not every, you know, low-level employees may not need these things, but it's possible that if you have a class of employees who sort of mid-level employees who you normally wouldn't have an employment agreement with, you're going to want to have a standard form employment and will agreement to cover these things in order to prevent liability down the road.
And what should a business owner look for when hiring an attorney to put together this employment at will agreement?
You know, I'm kind of a broken record on this, but I think that, you know, there are a lot of transactional attorneys out there who say, you know, I'll do contracts for you because I'm experienced with contracts, and that's great. But I also think that a business may be well served by having an attorney who's experienced in litigation, who has seen the kinds of things that lead to litigation and can avoid them in the drafting so that they don't happen again.
That's very helpful. And so you would fit into that category.
Yeah, unfortunately, it's
as a litigator for over 30 years.
Sounds like a long time to use that.
Well, especially when I emphasize the first syllable, 30 years. So let's tell people how to find you. So you can reach Sam at email, sam@samventola.com. You can also, on our website, if you go to ventolalaw.com, you'll find an online calendar system. If you want to set up a phone consultation with Sam, you don't even have to call me. I mean, I would love to talk to you, but you don't even have to call me. You can just go online and sign up for a time. No harm, no foul. If you want to know more about the podcast, you can subscribe to our YouTube channel, Sam the Answer Man podcast. You can also find us, for you audio fans, iTunes, again, Sam the Answer Man podcast. We're on Instagram, Sam the Answer Man. We're on Twitter, Sam the Answer Man, because somebody else had the, but that's okay, we moved on. Stitcher. You can also find us on Spotify. You can also find us on Facebook. So sometimes we post some clips from these podcasts there, as well as all the other social media channels that we have out there. But most of all, we want to make it as easy as possible for you to find the information you need. That's why Sam is our answer man. As I mentioned, he's been practicing for over 30 years. I love when he rolls his eyes at me when I mention that. In full disclosure, I've been in the legal industry for 26 years, so
That's a long time too.
That's kind of a long time too. But in any event, thank you so much for watching, for listening, for supporting us, and we look forward to doing more with you. Have a great day.
Thank you.
If you would like to discuss your legal issue with Sam, please contact Ventola Law at 303-864-9797 or check out our website at www.ventolalaw.com. Ventola Law, mediation and legal representation at an expert level.